Right, on to this story now, one of our top stories today. The appeal filed by former President Jacob Zuma and former Correctional Services Chief Arthur Fraser regarding Zuma's medical paroles decision has been dismissed with cost. Zuma does not, however, have to go back to jail. To discuss this further, we are joined by the Institute of Race Relations Head of Campaigns, Gabriel Cruz, or Crouse rather, who joins us now virtually. Thank you, Mr. Crouse, for your time here on All Angles. Just first of all, in terms of this judgment, when I read the order, point number 4 says it is hereby directed that the third respondent, which is President Jacob Zuma, be returned to the custody of the Department of Correctional Services to serve out the remainder of his sentence and imprisonment. But of course, I assume that he doesn't have to go back there because the court considered that by this time he'd be out of jail already?
No, that's not quite right. So the court said you've got to go back to jail.
Yes.
Zuma has got to go back to escort.
Yes.
It then says, in its opinion, the decision about whether the time he's been serving outside qualifies as time served or whether it doesn't qualify.
Yes.
In other words, the question about whether he should go back for 1 day or 13 months, that question must be answered by the Department of Correctional Services, not the court. So he has to go back to jail, but the department can decide, is it for 5 minutes to fill out the form to say time served, or is it for another 13 months? And I think whether that actually happens is going to depend on whether the police enforce the court's order for him to at least go back for a moment. And of course, last time the court gave an order that Zuma has to go to jail, the police tried to duck out of it, and there was that whole story, and we all watched at midnight when he finally went. Something like that could happen again, I suppose.
All right, so Mr. Crouse, then it's incorrect then to say that the court has said that he doesn't have to go to jail. The court has basically said that Correctional Services and the Department of Justice and Correctional Services will make a decision determining whether or not the former president still needs to serve a few days, a few weeks, or none.
Correct. So his original sentence was 15 months, and he'd only served, nearly 2 months. But then, you might say he served the rest of it under medical parole, although unlawfully, because Arthur Fraser had clearly unlawfully released him, according to the High Court and the Supreme Court of Appeal. Or you could say, even though it was unlawfully, it still counts as time served. That's the debate that the court says it doesn't want to decide one way or another. That's going to be up to the department. And so, the department is stocked by political appointees. Are they going to show a loyalty to party alongside with their ANC comrade, or are they going to show a loyalty to the letter of the law? I suppose I should say that from the point of view of the Institute of Race Relations, we gave a different argument about why Zuma should in fact go back to jail. And that was that he wasn't only unlawfully released by Arthur Fraser because he overlooked the Medical Parole Board's assertion that Zuma doesn't qualify for medical parole. He was also unlawfully released in the sense that it wasn't the department's situation to decide one way or another whether he deserves parole. Only the Constitutional Court should have been allowed to decide. Now, just to be clear, the Supreme Court of Appeal disagreed with us. I think they've clearly contradicted themselves in doing so. And so the question of our argument as a way to understand that Zuma deserves to be in jail and that he never should have been released and that his time outside doesn't qualify as time served. That argument is currently contested, but it's one that I think that we should be able to win on if we're given the chance to take it forward.
So, of course, this doesn't mean that, everything is over with this case in particular for the former president. What other legal avenues can he take? Because, of course, we have seen that the former president does like using all the legal avenues that are available to every citizen in South Africa. Will he have to go back to the same constitutional court that sent him to jail for 15 months if he decides to challenge the findings by the Supreme Court of Appeal?
Excellent question. The first point of contention is going to be, since the SCA says he has to go to escort, at least for a moment, maybe he will try to resist that and try and use that as a pathway to appealing to the Constitutional Court. I don't think that can possibly work because that's not like the kind of order that you can appeal against. What could happen is if he does go back to jail and the department says, look, you didn't serve your time outside of jail lawfully because you were released unlawfully, so you've got another 13 months to serve. He could then appeal that to the Constitutional Court, and I'm sure he'd find many opponents to argue the other side. But the other way that things might go is that he might never go back to jail because the police don't really read the order too carefully and so never enforce it. Or he goes back just for a moment and then they say, time served, you can go home now, go back to Nkandla if you like. And he goes back. The parties on the other side, they might consider then taking that up on appeal and saying, look, the remedy of saying it's up to the department to say one way or another, does this time count as time served? That can't be up to the department's discretion. Because what does that mean? It means the department made a mistake. It released him unlawfully. There's no doubt about that. And then the department can fix its own mistake by pretending it never made that mistake. That doesn't make sense. And I'm putting it in a layman's fashion. But, our lawyers have been explaining it to me in fancy legal language. And I think the law really backs up common sense, which is that if you've unlawfully released the guy, you can't fix that by just saying, well, ignore it. It's fine. He's out. Let's move on with our lives. We can't move on with our lives because Jacob Zuma broke the law. He violated an order from the Constitutional Court to go and give evidence about state capture. We all, as South Africans, have an interest in transparency and accountability, and the only way you get that is by getting the evidence. He violated the simple order to just go there and answer questions. He could refuse to answer some questions by saying, I think I might incriminate myself if I answer this and that. That is his right. That can never be undone. But he can be ordered by a court to go to testify. We all are in that kind of position. The court can order any of us to go and testify. He flagrantly violated that order and then only served 1.5 months of his 15-month sentence, further flagrantly, basically violating the rule of law. As South Africans, our position at the Institute of Race Relation is our best way forward is if no one is below the law. Apartheid's terrible sin was to put millions of people below the law. No one can be below the law. Zuma must have his rights, and they must be respected. But no one can be above the law either. No one can refuse to obey a court order and then go to jail for a month and then be unlawfully released by Arthur Fraser. And then we all wash our hands and say, it's fine.
Speaking about Arthur Fraser, I mean, of course, it was found that his decision was unlawful and unconstitutional and that it was invalid, right? He took the wrong decision and he was then also ordered to pay the cost of the applicant, right? Is that enough reparation? I mean, we're not only talking about former President Jacob Zuma here, and we all know that there are some people who would view it as a political connection, and that's how he got out unlawfully, now that the courts have said it was unlawful. But at the end of the day, he's not the one that made the decision to get out of prison. He applied, and someone gave him the green light. So what should be happening to Arthur Fraser? Is the financial aspect of the judgment enough reparation against him?
Absolutely not, because remember that the respondent is the Department of Correctional Services. So it's you and I that are paying those legal fees. This is one of the terrible things about how it works, is that costs get mulched when a government department makes the mistake. Ultimately, it falls on the head of the taxpayer. So I think this falls within a broader frustration that we at the IRR have had for a long time, which is the issue of personal accountability versus departmental accountability. This is exactly the kind of case that I think the public protector should be intervening on, to say, okay, the court has made this ruling. The court hasn't been asked to further explore this question of, was there a palpable corruption here? The court has just been asked, was this lawful or unlawful? And, were the arguments for its lawfulness so silly that you've wasted our time, so you must pay for the other side's lawyers as well, but you being the department. I think that this question that you've asked, is there something extra that needs to happen with Arthur Fraser in order to protect us from the next Correctional Services Commissioner just letting someone
like
else
an
off,
example being made,
for
right?
whatever reason? Exactly. That's exactly the right question. And I think that question needs to be directed at the public protector, because after all, it's the public protector whose job it is to make sure that government departments aren't being occupied by people who are taking advantage of their sovereign authority in order to, get away with skullduggery, and then when the chickens come home to roost, they just get the taxpayer to pay. So one of the things that the IRR will be exploring is seeing if we can draw the public protector into such an investigation. And another thing the IRR will be exploring with our legal team is to see whether an appeal is going to need to be made in order to vindicate the special law of contempt of court, in order to protect administrative justice in this country on the principle that no one's below the law and no one is above the law either.